Hello, Colorado Realtors. I'm Scott Peterson. Thank you for joining me for another edition of Legal Bites. I'm going to talk today about a topic that I think there's confusion about, or at least on the legal hotline I hear a lot of people that have a little bit of confusion, brokers that have a little bit of confusion related to what they can and can't do in this specific area. And it's not really a fine line, actually, but it's pretty clear cut, but I think there's a misperception among a lot of brokers. And so the topic today is the unauthorized practice of law versus a single-party listing agreement, which is the appropriate way to go through this scenario. So let me talk real quickly about what the typical scenario or the phone call that I'll get is, and that's it. A realtor will call and they'll say, hey, listen, I've got a neighbor, a family member, or a friend, or somebody, and they're selling their house, and they've already got the buyer. They're selling it to a friend of theirs, and they know that I'm a realtor, but they need somebody to prepare the paperwork. They need me to do that, and I don't have a listing on it. They just want me to prepare the contracts and kind of write the offer and make sure they do everything okay. Is that okay? Can I do that? And oftentimes they want to do it because, you know, as the broker, you don't have to market the property, or you don't have to work with a buyer where you're driving around and finding properties. So they expect you to do it for a much reduced fee, or maybe a flat fee, or maybe no fee at all. That's the general scenario that I hear on the hotline. And then, you know, is that okay? Can I do it? The answer is yes, but you have to do it pursuant to a single-party listing contract. So you can't just prepare the contracts. You work in the contracts all the time, and your license is the limited license to practice law. But that has to be done in every case pursuant to a brokerage relationship with one of the parties. You've got to have a brokerage relationship to the transaction in order to use the state form contracts and all the things that you're used to using on a typical basis in a typical transaction. So yes, you can do that for your neighbor, your friend, your family member in a situation where they've already found the buyer and seller are identified, and you're going to be working on the transaction. But there's a couple of caveats to that. You have to have some sort of a brokerage relationship, and that's going to include a single-party listing agreement. So whether you're going to work with both parties or work as a transaction broker on behalf of both parties in the transaction, which is probably the appropriate relationship in the scenario that I've just described, you're going to have a listing agreement on the property for just that buyer. So your exclusive right to sell listing contract is going to say you're a transaction broker. You could be an agent as well, but in that case you're going to give a customer disclosure to the buyer in that situation. But you're going to have an exclusive right to sell listing agreement that is going to identify the property that you're selling, and it's going to identify within that listing agreement that you're selling it, that engagement is only to sell it to a specified pre-identified buyer. And conversely, with the buyer, you're going to have an exclusive right to buy specifically just that property address. In both cases as a transaction broker, or working as an agent with one party and making sure that the other party is being provided with a brokerage disclosure that you're treating them as a customer. So you have to have a brokerage relationship with one or both of the parties in order to do that. And the important thing that I think a lot of brokers get caught up on is that you have to also perform, at a minimum, if you're acting as a transaction broker, all of the uniform duties. So everything under paragraph 5 in the exclusive right to sell or exclusive right to buy, all of those uniform duties, you also have to perform. So you can't just write up the contract, give it to them, and let them, send the two parties off on their merry way. You have to actually perform the uniform duties, even though you're doing it for a reduced fee. Now, your exclusive right to buy and or exclusive right to sell listing agreements can memorialize a reduced fee. You can do it for no dollars. You can do it for $1. You can do it for a flat fee. I'd probably avoid doing it for an hourly rate or anything like that, because that gets into some, at least in my opinion, some unauthorized or practice of law kind of considerations. But you can certainly do it for any fee. There's no set fees, as you all know. You can do it for any fee that you want to do it for as a favor to them. But you have to have an exclusive right to sell or buy, or some relationship with the party, some brokerage relationship with the parties to the transaction. Otherwise, if you're just doing it in some other capacity, then you're probably doing it in the capacity of a lawyer, and that is the unauthorized practice of law. So it's a very, very fine line. and you're free to do it, but make sure that you have a brokerage relationship in some fashion with one party or another or both to the transaction. So hopefully that clarifies what I see from a lot of confusion from brokers that call the hotline. If you have additional questions or want to explore this topic a little bit further, hotline's always available from 9 to 12 and 1 to 4 Monday through Fridays. Please take advantage of it. It's a great resource for all of you members. Thank you again for joining me on another edition of Legal Bites, and we'll see you next time.